Finance. I'm joined today by Travis Mott, counsel at Rakower Law PLLC. Our conversation will focus on wire and cheque fraud, an ever-growing business problem. This conversation will serve as an introduction to the law concerning wire and cheque fraud and recommends best practices for businesses to mitigate risk and preserve claims. So, Travis, tell us about the problem of wire and cheque fraud.
Of course. First of all, thank you for having me. Wire and cheque fraud encompasses theft, forgery, or manipulation of payments made electronically or by check. In our fast-paced online world, bank customers' accounts are just a few clicks away, and wire transfers can be conducted as quickly as the bank is willing and able to process them. In a matter of minutes, millions of dollars can be transferred. A 2022 FBI report recorded 22,000 complaints of fraud worth $2.7 billion in connection with a single category of wire fraud scams known as business email compromise. Sophisticated fraudsters don't just hack into accounts. Instead, they use phishing scams and social engineering and SIM card swaps to trick account holders into giving the fraudsters access to the accounts. In these sorts of scams, fraudsters contact businesses posing as bank representatives and claim that the company's bank accounts are under attack. Fraudsters will often conceal their identities by spoofing their phone number so that they appear on caller ID to be calling from a legitimate phone number associated with the bank. They will also try to gain the victim's trust by providing certain information about the bank and the customer's accounts that only a legitimate bank employee would be expected to know. Once the fraudster has established credibility, they will ask the victim to provide the passwords, PIN numbers, token codes, or other access credentials for the bank accounts, claiming that they need that information to reset the login credentials or to reset security measures on the account. In truth, the fraudster is using that information to execute wire transfers out of the account as quickly as possible. Some scammers will even take the additional step of using their account access to deactivate account notifications so that the company doesn't even see the wire transfers in real time as they're happening. As for check fraud, despite the broad availability of electronic banking and payment tools, a surprising number of substantial business transactions are still conducted by check. And check fraud is on the rise too. In February, the US Treasury reported that check fraud had increased 385% since the pandemic. One way that fraudsters commit check fraud is by intercepting checks from the mail, then modifying or replacing those checks and depositing them in the fraudsters' accounts. That sort of check fraud represents a major risk for companies, because some companies conduct routine transactions by check. So often, a fraudster who is inside the company and has access to company mail gains knowledge of certain routine payments made or received by check and is in a position to intercept them. If a company is not diligent in its monitoring of those transactions, dozens or even hundreds of checks can be intercepted before the company realizes that anything is amiss. Check fraud is also becoming more sophisticated. Techniques like check washing allow fraudsters to copy the face of a check, digitally alter that content, and then reprint the content on new commercial check paper. This technique can be incredibly difficult for banks to detect, because the check that is presented for payment appears on its face to be authentic and unmodified. The fraudsters will also routinely attempt to avoid detection by distributing stolen checks across a network of conspirators and banks. Usually, the fraudsters who commit wire fraud or check fraud are never found. So the fraud victim is left to seek reimbursement from the banks involved in the transaction. And that is often where the law comes in.
So, what law governs liability for these fraudulent transactions?
Generally speaking, check and wire transfers are governed by the Uniform Commercial Code, also called the UCC, which is a set of proposed laws that govern all sorts of commercial transactions. Most states have adopted their own version of these uniform rules, and those state laws can vary a little bit. So anyone considering their rights and obligations in a particular situation should review the UCC provisions implemented by the state whose laws would govern the transactions under consideration. Separately from the UCC, consumer bank customers have additional protections under federal law called the Electronic Funds Transfer Act, or EFTA or EFTA. That law creates a separate set of protections for consumers when they transfer funds electronically. EFTA covers debit card and ATM transactions, but also transfers initiated through an online bank portal or a phone app.
And are there remedies that the UCC gives to victims of fraudulent transactions?
Yes, the UCC creates a framework of liability for bank transactions. And the goal of that framework is to allocate responsibility to the party in the transaction who committed culpable conduct, or to the party best positioned to have prevented the fraud. As a starting point, the UCC says that a bank may only charge its clients' accounts for transactions that are authorized by the client. If the bank debits a client's account for an item that is unauthorized, then the bank must typically reimburse the client. The concept of authorization is critical here. Authorization is interpreted from the perspective of the bank, not the perspective of the customer. Obviously, we wouldn't ordinarily think of a transaction as being authorized if the account holder was tricked into issuing authorization or facilitating the transfer. But the UCC will treat that transaction as authorized if it was submitted to the bank via ordinary channels that are controlled by the account holder, and the transaction complied with the procedures and security protocols on the relevant bank account. So you can quickly see how authorization becomes problematic for clients who are the victims of phishing or social engineering schemes, because in those schemes, the fraudster tricks the account holder into providing information that allows the fraudster to submit transfer instructions to the bank that appear to be authorized. In such cases, banks often take the position that they have no duty to reimburse the account holder for that transaction. Fortunately, victims of these frauds may still be able to maintain a claim for reimbursement. First of all, they can maintain a claim for reimbursement from their own bank because the bank remains liable if it accepted payment instructions in bad faith or in violation of its own procedures. The account holder can also maintain a claim against its own bank if the security protocols on the account were inadequate and unreasonable, and the bank had failed to make other more appropriate security measures available to the client. Now, most courts have found that the victim of wire fraud can only pursue reimbursement from its own bank, and that the receiving bank, the bank that receives the wire transfer from the victim's bank, is not liable for the transaction unless that bank received the payment with actual knowledge that it was fraudulent. However, a recent decision from a federal court in Virginia allowed a fraud victim to recover damages directly from the bank that had received the wire transfer. In that case, the court found that the receiving bank was liable because it had failed to do due diligence on the new account opened by the fraudster, and because the bank had failed to exercise reasonable diligence to investigate several common markers of fraud that were associated with the wire transfer that the bank received. That decision is currently on appeal, but if the trial court's decision stands, it could dramatically alter the liability landscape for wire fraud.
That would be interesting. Can a consumer lose its right to reimbursement for an unauthorized payment?
Yes, this is an important point. Even if a payment is unauthorized or otherwise reimbursable to the customer may not be entitled to reimbursement if the bank can establish that the customer failed to act in a reasonable manner with respect to its accounts or its checks, and if the customer fails to notify the bank of the unauthorized transaction reasonably promptly. Now, the UCC doesn't define reasonable promptness, so customers need to make sure they know any deadlines imposed by their account agreements with the bank, and they generally must take steps to monitor their accounts on a regular basis so that they can report suspicious activity as quickly as possible.
And are there special considerations that apply to checks as opposed to electronic transfers?
Yes. Let's imagine that a fraudster deposits or cashes a fraudulent check at his or her bank. We'll call that bank the presenting bank. The presenting bank reviews the check that it receives from, in this instance, the fraudster, and then presents that check to the payor's bank for payment. And let's call the payor's bank the paying bank. If the paying bank honors the fraudulent check and debits its customer's account and transfers the money to the presenting bank, then the paying bank is liable to reimburse its customer for the reasons that we discussed moments ago. But the UCC may give the paying bank a right to reimbursement from the presenting bank. The liability between the presenting bank and the paying bank depends on the nature of the fraudulent check, specifically whether the check was forged or altered. A forged check is one that is entirely illegitimate, which is to say a check that the payor never issued or at least never signed. An altered check is a legitimate check that was issued by the payor, but that was later modified without the payor's consent. Common modifications include changes to the check amount, to the identity of the payee, or to restrictive endorsements on the check. The paying bank has the account relationship with its customer who is defrauded. It is familiar with its customer's typical banking activity, which is to say the sort of checks that its customer usually writes. It's also aware of any restrictions that may exist on the payor's account. And it has a copy of the payor's signature on file that it can compare to the signature on the check that is presented to it for payment. For these reasons, the law considers the paying bank to be in the best position to identify forged or counterfeit checks. If the paying bank honors a forged check, it must generally reimburse its customer. The presenting bank, on the other hand, gets the first look at the check when it is presented to it by the fraudster in this instance, who is seeking to deposit or cash it. The presenting bank is presumably familiar with that individual, or at least has an opportunity to evaluate them and whether they are an appropriate signer of the check. For this reason, the law considers the presenting bank to be in the best position to identify modifications or alterations to a check. So if the presenting bank presents an altered check for payment, then the presenting bank may be required to reimburse the paying bank for any amounts that the paying bank ultimately refunds to its customer.
And how does EFTA differ from the UCC?
EFTA differs from the UCC in a few ways. First of all, as I already mentioned, EFTA only protects consumer banking customers, so it doesn't apply to business to business accounts. Second, it only applies to electronic transfers. That means that it doesn't apply to fraudulent checks or to unauthorized transactions that are conducted at a bank counter. Substantively, the biggest difference between EFTA and the UCC is how they approach frauds in which a customer has been tricked into facilitating the transfer. As we discussed a few moments ago, under the UCC, the bank is not liable to the customer for such transactions because the UCC deems them to be authorized. But under EFTA, the bank is liable to reimburse the customer unless the transfer was actually and intentionally authorized.
And do you have any recommendations that you would make for best banking practices?
Absolutely. Several simple precautions can reduce vulnerability to fraud. First, whenever possible, bank electronically instead of using paper checks. As we have seen, electronic transfers are not immune to fraud, but they are protected from certain types of fraud to which checks are vulnerable. Second, work with your bank to implement the most robust available security measures for your accounts that work within your banking needs. Third, if you must send large sums of money by check or wire, verify that the payment and delivery details are correct, ideally by placing a telephone call to a person or a phone number that you know to be legitimate. For business accounts, the fourth recommendation would be to limit the number of people who have access to the accounts and train those people on how to recognize phishing and social engineering scams. In addition to those preventative measures, a few basic remedial measures can help ensure that you timely discover fraud and preserve claims. First, if you regularly conduct business by check, implement a system of oversight to ensure that checks are processed timely and correctly. Second, review bank statements promptly and confirm that all debits are legitimate and that all checks have been signed by an authorized signatory. If you discover potential issues, alert your bank immediately. And lastly, hire good counsel to help you complete your investigation and advise you on next steps to recover your funds.
Thanks for that, Travis. A great set of recommendations and advice that I think everyone should be paying attention to. This is, a really insightful discussion, I think, and I think it's something that's going to be something that people refer back to again and again for that advice. Thanks very much for it.
That's wonderful. Thank you for speaking with me.